Today on Trial or Nation, I'm back with my partner Malorie Peacock, and we are doing our trial series. How are you doing today, Malorie?
Good, good. I'm so excited to be continuing on with the trial series. It's a fun idea for the podcast, and I'm really enjoying it.
Plus, it helps us psych ourselves up for our next trial in a couple weeks.
Yeah, yeah. I'm getting excited.
So today we are doing my favorite topic: cross-examination of defense medical people. I don't want to say experts because I don't think they're experts in anything other than lying for money, but they do get paid to testify on medical issues. So, Malorie, start us off.
This feeds into kind of the last two pieces of the trial series that we did. The first one was about doing the 30-minute witness, and the last one was about presenting our own medical treatment providers for our own clients during a deposition or through trial. So my first question for you is, can a cross-examination also be less than 30 minutes?
Not only can it, it usually should be less than 30 minutes. Now, there's always exceptions, but in general, a short, great cross-examination is better than a long one where you make every point you could possibly make, whether it's your best point or not. And it actually reminds me, this is more than 20 years ago, I'm getting old, but I was lucky enough to be on the staff at the Jerry Spence Trial Lawyers College once, and for a period of time. And I was there in Wyoming. We're at the ranch. We're at our staff training, and we're doing practice cross-examination demonstrations. And so I do one, and I thought I did such a good job, and I kept going, and Spence stops me. He goes, "Michael, you did a perfect cross-examination." So my head is getting ready to explode. Jerry Spence tells me I did a perfect, but then you kept going and you effed it up. He didn't say effed, but yeah. And, but it taught me a valuable lesson. Like, I got my point made, but then I kept going to a weaker point, and it wouldn't stop talking when I made my point. So I do think that the most important thing on cross is to make your best points and sit down and stop talking.
Yeah. Yeah. And how do you, when you're thinking about developing a cross-examination or when you think about preparing, how do you figure out what are the best points that are really going to resonate and what's just kind of a nitpicky thing that isn't going to really land?
So the biggest thing is, what is my story? What is the story I'm trying to tell in the trial? And then what part of the story can I tell with this particular witness? And it's going to be different. So if my trial story is, defendant driver isn't paying attention and causes permanent harm, and I have a defense doctor that will admit that my client has pain, that he didn't have before the wreck, we might quibble over other things, well, then maybe that's the story I want to tell through the doctor. If the story is, here's someone that's bought and paid for trying to help them cover up and get away with it, and that's why they're the villain, then that's my story, and that's a different cross. So I think the biggest thing is trial is a story, and what story can I tell with this witness? And it's really going to depend on which defense doctor it is, because some will fight you on everything, and some will give when it's appropriate, and some will give almost anything if you're nice to them.
Yeah, I think that that's important. I think one of my favorite things that you always talk about is you don't have to tell your whole story through every single witness. The whole trial story comes together the way that it comes together, and the jury will get it. But they do not like when you keep repeating your points and you keep cross-examining, especially other witnesses, about things they don't know anything about. And so, you're trying to tell your story just to get, I don't know, answers, or that's not my expertise. Jurors hate that because they feel like you're just beating a dead horse. They just really dislike that.
Or if you're just arguing with them. I mean, that doesn't do well either. Like, doctor, you're wrong on this. No, I'm not wrong. I mean, if you can't prove they're wrong, well, then it's a problem.
Right. So where do you like to start your cross-examination? Do you like to start with their qualifications? Do you like to start with what they did in the case? I mean, do you have a template, or do you start somewhere different every single cross?
I don't have a template because I think that's dangerous. I think the template is, what story am I trying to tell through this witness? Although I do have, and when we were preparing for this episode, a collection of things that do tend to work. One thing I tend to start with, and I think 9 out of 10 times I actually start with this, and I totally stole this from Keith Mitnick's Don't Eat the Bruises. So I didn't come up with it, but I use it effectively. And thank you, Keith. You're a friend, and I appreciate you sharing this with us. is showing who the witness is. So a lot of time they've made such a big showing on how they're such medical experts, all the different medical training and background they have, what kind of treatment that they provide to their own patients. So I think showing that they're picked and paid for it. It's 2 or 3 questions. Like, you are not, John's doctor. You were picked by the defense lawyer in this case. You're being paid by the defense lawyer in this case, or by the trucking company, or whoever it is. But, just start off with those 3 questions, right away. This is who you are. If they did not do a medical examination of your client, I might go on. You never performed an examination of John. Not only are you not one of John's treating doctors, you've never spoken to any of John's treating doctors about this case. And you've never, even spoken to John. You've never even seen John in person before you were here in the courtroom today. Isn't that true? Just to go show this is someone that's a paid advocate. This is someone they picked, they paid for. It should not take more than a minute to get through that unless they're really talkative on their side. But the more they're talking and trying to weasel away from that, the better you are.
Yeah. I think this is a good part in the cross-examination too. I mean, you got to do your homework when you go into a cross-examination. You have to know what it is that doctor actually looked at and did. And so pointing out anything else that they didn't do. So sometimes I'll see that the defense never sent them the plaintiff's deposition, for example, or they're missing a big chunk of records, or they're missing critical information about your client that they should have had and they didn't review. So you kind of group that in, I think, all at that same time. You establish that they're picked and paid for by the defense. And then because of that, here's all the things that they didn't do that a regular treating doctor would do.
And I love really even creating a chart and contrasting what the treating doctors did with what the paid defense doctor did. And the more visually you can show it, the better. So like, these 8 doctors are the treating doctors. They have a physician-patient relationship. You are not a treating doctor. You don't. They spoke to him and took a history. You did not speak to him. They performed a physical examination. You didn't perform a physical examination. You go through the things that, just to show the difference, it makes such a difference. And then, if they're basing it mainly on the medical records, you have to know your medical records, because 99 times out of 100, they will misrepresent what is in those records. They either omit what's bad for them, or they even say things that aren't true about what's in those records.
Right. I often find that they just cherry pick key phrases from a record, but when you review the record in its entirety, it doesn't say what they're saying. A really good example that I see all the time, especially in a lower back pain case where someone is getting therapeutic injections, right? They're getting some kind of epidural steroid injection or something like that to help with pain. And the defense doctor will say, and they told the doctor they had no more pain on this day. And when you review the record as a whole, you realize that 2 days before they'd had an epidural steroid injection. And that's the purpose of that injection, is to completely alleviate pain. So it makes sense when you read it as a whole.
Absolutely. And that's where they lose all their credibility. My favorite one was from the case Sonia and I tried last year. And, it's like the doctor says, she had back pain before. She must have had these disc problems before. And when I pulled up the record from that, because he just had the date, when we put up the record, it says has back pain with ovulation, goes away when she has her cycle. I'm like, okay, doctor, you're telling me that's from a herniated disc. Yes, I am. Okay. I don't need to keep going on about that. I had more women jurors than men. They know this guy is a liar. Really, really easy. But, we had another fun one in trial where they don't always read all the records. They often have someone else summarize the records for them. They may not admit that, but they are relying on a summary. And one great thing about that is often they only look at what's typewritten and not what's handwritten. Can you tell that story when we were in trial?
Yeah. So this was, this wasn't necessarily about the medical injury or the medical treatment, but the doctor was doing an analysis of what probably happened in the crash, trying to compare the injuries to what we said happened in the crash. And the issue is that the doctor said, I hear your story, Mr. Cowen, right? I hear what you're saying about what happened. But if that happened, there would have had to have been some evidence in the records anywhere of ecchymosis. And
yeah, he said bleeding, bruising, or ecchymosis. And he used the word ecchymosis. And we looked at each other.
We looked at each other because we had reviewed the records. And Michael says, well, tell me a little bit about what ecchymosis means, right? And so he goes on, he says, well, it's like bruising, bruising is basically the way that he described it. And you pull open the emergency room records, and in the handwritten intake chart, there was a big black drawing all over her leg that looked like a bruise. And right next to it, it said ECCY, which means in shorthand, ecchymosis, right?
Yeah.
And because it was handwritten on there by one of the intake people, it wasn't in a summary. He didn't know that it said that. And it was a big moment in the trial because we had already spent a lot of time explaining what that word meant to the jury. We had a medical dictionary, and we kind of knew that's where it might be going. But
Yeah, I think that's another point too. If you know you have things, you have to plan out your crosses in advance. You can't just wait till the night before. And so if you know you have things where you may need to use medical literature, like in this case, we actually, when we had our expert on, we proved up a medical dictionary as a learned treatise. So that was reliable authority on what the term ecchymosis meant, that the picture in the medical dictionary fairly and accurately represented ecchymosis. So when the defense doctor said there was no ecchymosis, then he tried to, like when we showed him that the medical record said it, then he tried to say, well, that really means something different. And he tried to change it. And then we were able to get the medical dictionary out, have him read the dictionary definition, which said something like black, blue, it looks like bruising, and then show the picture and have each juror pass around and look at the picture of something that looked like a bruise. And so it was so awesome that we got to do that. But had we not had our own expert prove up that learned treatise, and there's so many great things, radiology textbooks, other medical textbooks and articles, if you know that you might want to use them to cross-examine the defense doctor, then you definitely want to have them proven up as a learned treatise. And just a couple, you don't even have to use them with your expert. Like, doctor, have you seen this article? Have you seen this chapter? Is this a reliable authority on X? Yes, it is. That's it. Now you can use it to cross-examine because you've established your foundation. And a lot of times the defense doesn't even read them. It's crazy.
yeah, well, and they don't really know what you're doing with it, I think, as a big part of it. And in that case, we spent a lot of time proving up this medical dictionary, talking about ecchymosis. And I don't think the defense realized it's because we knew their expert didn't realize there was ecchymosis, right? We knew from his report that he missed that piece of it. And they still didn't tell him, I think, because they just didn't put it all together. They didn't tell him before he was cross-examined and this happened on that stand. We thought for sure they would go back and tell him what we were doing, which is why we were surprised it still happened in trial, but it did.
And I'd also learned from Todd Tracy, who had cross-examined him a month before, that he didn't actually read all the records himself. He had someone else summarize them for him. And so I knew there's a good chance he would have done the same thing in our case. And so that's another one, collaborating with other lawyers is really helpful in cross-examining these people and really bringing out the truth. But we got a verdict. We had actually made our client sign off in writing that she was going to trial against her advice and told her to take an offer, and we got a verdict for 10 times that offer. I'm so happy we were wrong. But we frankly could not have foreseen that. I think that cross-examination won that trial for us.
Yeah. I think it really drove home the story that we were trying to tell in that case, which is that they were denying the facts right in front of them. I mean, right, we were here because of the defense. We weren't here because the plaintiff was being unreasonable.
Yeah. And then I think the other thing is really, getting to know the medical literature. And, if you have really good quotes from the literature, you get this a lot in traumatic brain injury cases. Prove it up with your doctor. Sometimes you want to show the literature first with your doctor so the jury reads in advance. But sometimes you just want to leave it there and just have the doctor prove it up and then wait and just be prepared. So now it's like you've got the treating doctors, you've got your doctor, you have the medical literature, and then you have the defense doctor. And then I think and you're really good at doing this, if the defendant's doctor cites any kind of literature in their reports or in their depositions, get it. Because how many times have we had them say, this study shows X, and when we get the study, it actually says the opposite?
Right. It happens a lot. I would say, most of the time when I get the literature, the literature may sort of say that, but not really, right? And but most of the time it doesn't say that at all. It actually says the opposite of what they're trying to say that it says, which is interesting because I think in medical school, doctors are required to learn how to read medical literature. And so they're doing it on purpose, right? As the long and short of it is they think you're not going to read it. They think you're not going to look at it. They think you're not going to know how to read it. And so getting that information, that's one of my very, very common questions and discovery depositions. It's not a trial deposition. It's tell me all the literature. Tell me any literature that you might put in front of a jury and give me a list and make them list it all out, even if it's not in their report, because I want to go find it first so that I can show that they're misquoting it.
Absolutely. So what's another good technique?
So, one of the things that I like to do is get what you can get easily, right? Most doctors, there's some doctors that'll just argue with you about every single point. Most of them feel bad about that, right? Like they feel intellectually dishonest. And so they're going to give you some points. The way that you find out what points they'll give you is you go back and you read past depositions of theirs. I mean, that's the easiest way to do it, is you kind of go back and you see, okay, what kind of witness am I dealing with here? What have they given other people? What have they agreed with before? And then you try to get them to agree with those same points. Most of these testifiers are consistent, right? They try to be, at least, across their depositions, because they know how bad it looks if they're not consistent across depositions. So if one person has gotten them to admit something before, chances are you're going to get them to admit at least a piece of that same thing, only because they know their career rides on consistency in their opinions. Yeah. So a lot of times I'm able to just lay out kind of an easy to follow formula. This person is in pain. You don't know whether they're in pain or not, because pain is subjective. They're going to agree with that every time. Disc herniations can be caused by car crashes. They're going to agree with that. They can be caused by other kinds of trauma. Disc herniations can get worse from trauma. Back pain can get worse from trauma, right? Those little one-liners give you a lot with the jury, because I think this goes back to what I said in the last podcast. You have to remember what you're trying to prove. You don't have to prove that a disc herniation was caused by the crash. Unless don't write me. If there's some different law in your state, okay. But generally, you don't have to prove that the actual disc herniation was caused by the crash. You have to prove that pain or limitation, impairment, something like that was caused by the crash. And so to quibble about the actual technical injury doesn't move the ball forward in your case. And so if you can get the defense doctor to admit, yeah, they probably did have pain, I just think it wasn't caused by this, that's still a big win for you in telling the story of the case.
Absolutely. And I do think, telling the story of like going through the different, I don't want to go visit by visit, but like, he went and saw this doctor 15 times over 12 months, and every single time he had pain in his back. And you've never seen a record from before we had pain in the back, and he's told you that he's pain in the back. Are you saying he's not telling the truth? And we heard from his wife that he didn't have pain in the back before, and he's had it ever since. Are you saying she's not telling the truth? Well, we've heard from his employer and his pastor and his next door neighbor. Are you saying they're not telling the truth? So you would agree in this case that all the evidence you have before you is he had no pain in his back for the 5 years before. He has a crash, and from that day forward, he's had pain in his back. But you're telling us that crash didn't cause that pain. Thank you. I mean, it's really easy, and it's fun. But it's when you don't get trapped in the weeds and start arguing with them over little things.
Well, Michael, you developed this sort of timeline exhibit that you use, and I've adopted it completely. I use it in almost every cross-examination of a defense doctor. But it's just a little timeline. It's just a little arrow on a piece of paper where just a point on the arrow in the middle is where the crash happened. And you get the doctor to describe what is all the treatment that they had after the crash, and you write it down. So they went to physical therapy. They, went and had an MRI. They whatever. And then in front of the line before the crash, you say, did they ever have therapy? No. Did they? And so there's nothing over there. And it's a really great visual. I guess I use it so much. I had a defense lawyer recently in a case who I busted out my little IP vote and started to draw. I just saw him go and roll his eyes and there's this whole scene about it. But, it's such an effective tool. And it really puts on the paper, because you have to be visual with medical.
Absolutely.
Jurors don't know it, the way that you do. And so just having that visual representation of nothing before, all of this after, really drives home the story you're trying to tell, which is this person was injured in the crash.
Yeah, I think the really big contrast is you've got, typically you have no evidence of pain before, you have evidence of pain after, or minor pain before, got worse after. You have all the other people. You can list them. Even better, put up pictures of them that say that. You have all the doctors that say that, and then you have like this one person who's on an island saying differently, who happens to be the only person getting money from the defendant. And it just makes a really compelling story. And it also helps, establish that the defendant's a villain because they're trying to say something false to get away with something or get out of doing something.
I know,
And so,
Michael, you
that's, go ahead.
I was going to say you've talked before on the podcast, but how many episodes are there now? Should 100
I
over?
think we're over 190 now.
Yeah. So you talked on an episode before about making the defense the villain, and just say something briefly about that in case people haven't listened to that podcast. Why would we want to do that?
Yeah, so we human beings think in stories, and we've been hearing stories since we were little kids. And in classic Western literature, and maybe that way in Eastern literature too. I haven't studied it, but we have certain archetypes for what makes a hero, what makes a villain. And a villain, basically, they're immoral. They don't care. They want to get what they want. They don't care what happens to other people. They're intelligent, they're powerful, and they're deceptive. So doctors are intelligent. They're more powerful than normal people. So that's why defense doctors make good villains. And when they're teamed up with a company, it makes an even better villain. But when they're trying to be deceptive, when they're trying to trick a jury, when they're trying to take things out of context, misrepresent things, then jurors can understand, hey, this is the bad guy, because good guys don't need to do that.
Right, right. And so when you're developing your story of the case, you're thinking in the back of your mind, how is the defense the villain? And sometimes the defense is the villain through the picked and paid for witnesses that they
Right.
get to testify in a case. Sometimes it's not the actual conduct from the day of the crash. I mean,
Yeah.
sometimes the crashes aren't that dramatic, right? Or, if you're
Right.
trying regular car wreck cases, it's just grandma driving to the grocery store, we rented your client. It's not that sexy of a story, but their conduct after is what makes them the villain.
Yeah. Now, sometimes this is advanced. It helps to try this in depo before you do it at trial. You can turn a defense doctor.
Mhm.
And sometimes it's just by definitions. I've had doctors where, they'll say, well, this is all degenerative. This is all degenerative. But they'll give you that trauma can make degenerative conditions going from asymptomatic, which is no pain, to painful, and that there's no evidence that there was any pain before this. And they will say, well, if the jury believes the plaintiff that he wasn't hurting before and he's been hurting ever since, then more likely than not, this was aggravated by the trauma, and the crash was the cause of all the problems. I have doctors where I've done that. Now, you've got to feel the doctor out. So I really recommend doing that in depo, not in front of the jury, because if it doesn't work, you want to be able to switch and use these other techniques. Also, really knowing your medicine. I had a guy trying to say everything. This was a trial I had in March. Everything was due to pre-existing conditions, and all the pre-existing stuff was disc stuff. And her MRI looked pretty bad before. She had an MRI like 10 years before, and it was pretty gnarly. But she had something called a radiofrequency ablation, which is a facet joint treatment that temporarily gave her 100% pain relief, which means that the facet joint was the cause of the injury. I knew that. I took a chance at trial. I just felt it and got the doctor to agree with me that radiofrequency ablation treats facet pain. It does not treat disc pain. He agreed. And that the radiofrequency ablation was temporarily 100% successful, which means it was facet joint pain, and get her to agree that no one had diagnosed facet joint pain, and then got him to agree that the incident in this case was more likely than not the cause of the facet joint pain that she was suffering for, and that it couldn't have been the disc stuff because now maybe I got a little luck, but he gave it to me. I wouldn't start off doing that, but when you learn the medicine, you sometimes get away with stuff like that. All the trial ad people would say, don't do that because you're setting yourself up. But when you get in trial, you get in a groove and you get a feel for what you can get away with. Sometimes it blows back on you, but it usually works.
Yeah, yeah. Well, and the good thing about the medical stuff is because you probably have more knowledge about the medical than the jury, you can see as you're doing your cross if it's going to blow back on you, and you can stop before
Yeah.
you get there, right? You can kind of see where they're going, what some of the medical stuff, how it's taking you.
Yeah.
So you just stop. I mean, if it's going badly for you, stop and move on to a different point. I mean, you don't have to see a point all the way through if it's not helping you.
Exactly. And hopefully, you have the medical literature ready to go support you. But in this case, it's kind of something I figured out on the spot. And,
Yeah.
Sometimes you just get a good hunch in trial. My last favorite thing on cross-examining defense doctors, I stole from Keith Mitnick. And that's when they say, well, they'll give you an injury, but they'll say, but it's a soft tissue injury that should have gotten better in 6 to 8 weeks. And you lock the doctor in there. If you're right, this is something that would get better in 6 to 8 weeks. And then you show the records that the pain didn't change after 6 or 8 weeks. And so, doctor, you're telling this jury that one day, somewhere between 6 weeks and 8 weeks, they went to bed with pain from this crash. And they woke up the next morning with the exact same pain, but it was from something else. I mean, there's no winning for them on that. Yeah. They either have to admit they're wrong, and they usually won't, or they just have to look like idiots. And most of them want to get paid on the next case to say the same thing, so they'll just choose to look like idiots, and then you've won.
One of the things I've seen you do, Michael, which is in cases, so I'm sure this doesn't only happen in our cases, but even when you have a client that's really badly hurt, right? They went to the emergency room, they were there for a month, they had all these kind of treatments and surgeries and all kinds of stuff. They still hire a medical doctor to say, well, they should be all better now, or they're fine, or right. Whatever they're going to say. In those cases, I've seen you use the defense doctor to tell your story about what the client has actually been through. So what have you done with that? How do you do that when they're going to say, well, yeah, but they should be all better, even though they have all these bad injuries?
Yeah. So I had one, and again, it was a severe injury, more than 20 broken bones, a severe traumatic brain injury. And the defense doctor, they hired him, and he didn't ever meet the client. He just reviewed all the records and said he got better. Right. So I had just two things I did. Actually, no, I did one with one doctor, one with the other. So the one doctor that reviewed all the records, I just went through all the records, just the hospital records, and just did a drawing of the body, and I just drew every single injury. And he had this injury, he had that injury, he had severe traumatic brain injury, he had a broken bone here, he had a tooth that broke off, and that tooth ended up in his lung, and they couldn't get it out. He had broken ribs, he had a broken arm. He just, drew them all out on one outline. And then that was it. I didn't ask him about his opinions of my client getting better. And that case settled right before jury selection, but my plan was just to play that as a direct. They didn't do a trial cross. They were going to call him live. So the jury would have already heard him talk about all the injuries my client had. Now, if they want to bring him back to say he got all the way better, let him. And then they had another doctor that said, my client got all the way better, but he hadn't carefully reviewed all of the therapy notes that my client, he said his brain injury was miraculous recovery and the brain injury was all the way better. And then I just made him read, actually I read to him and made him agree with me what it said, all the notes from that month where the therapist says he's still having memory problems, he's still having this problem, that problem, and just got him to look like he goes, well, I still think he's better. It was great. I mean, he was just, he's relying on the records, but he hadn't read them all, and he's totally being contradicted by the records he's supposedly reviewed.
Yeah. What I love about those two cross-examinations, they're two of my favorite ones that you've done, is that you did one thing in the cross-examination. It was one thing that you did. Yeah. You did that one thing, and that was all you did for that cross-examination. You didn't have to do everything, right? You didn't have to go, because you mapped out your story in advance. Like, how am I going to use this one thing to continue to tell my story? How am I not going to get into the weeds with this doctor about, exactly what disc level and all that kind of stuff, right? It's that one thing. And then with the next doctor, you did just that one thing, right? And so the jury hears from you about the one thing. And what did they hear from the defense right before that? They heard 45 minutes of expert qualification that they fell asleep during. And then maybe someone was talking way over their head about diagnoses they don't know anything about. And so they take that compared to your one very clear, succinct thing, and yours is going to be more powerful because it's short and to the point, and they get it.
Yep. So I guess in summary, when cross-examining a defense doctor, tell a story, and when you've told your story, stop. And so that being said, this is going to be a fairly short podcast because we've told our story, and now we're going to stop. Malorie, this has been a joy. I can't wait to our next trial together and watching you do some crosses and you watch me do some crosses. I get to watch you pick a jury. You get to watch me do an opening. It's going to be great fun. And everyone else, please join us next time on Trial Lawyer Nation.